Mr. Bartlett, who represents Mr. Ratliff. The court is taking up today an order to show cause hearing, and I'm going to briefly discuss the procedural history that brings us to this at this time. I'll note that this was a motion that was filed by Mr. Ratliff, who is a bar licensed attorney through the state of Idaho, and filed a pleading purporting to be the attorney for the defendant in this case. And the pleading was filed on March 29th at 11:42 p.m., so shortly before midnight on a Friday. And I do want to discuss briefly the timing of the filing. The court was conducting jury questionnaires and preparing for jury voir dire in this case, which of course is a capital murder case, an incredibly serious case where the court counsel has spent a tremendous amount of time preparing for and getting ready for trial where we are now. The court was not made aware of the filing because it was not entered in the case until Sunday morning on March 29th. That would have been on March 31st. That was Easter Sunday before we were going to start with our voir dire the following Monday. On Easter Sunday, my staff attorney, who had an opportunity finally to travel home and spend Easter with her family after a very long week, was interrupted out of her church services and contacted the court that we had an emergency happening in our case that was going. And the emergency was, we had a motion to continue the trial. And I wasn't sure who was asking to have the trial continued, why the trial would be continued, but this created a tremendous amount of quick response required by the court, by staff, by clerks, by the prosecutors, by the defense, all occurring again on one of the few days we had a break as we were grinding through jury selection on Easter Sunday. The pleading the court received is entitled Motion to Intervene and to Continue the Trial in These Proceedings, filed by Mr. Ratliff on his official office pleading letterhead, signed by Mr. Ratliff as the attorney for the defendant, both on the signature line and on the caption. I'll note the pleading incorrectly spells the word motion. It incorrectly spells the word continue. It incorrectly spells the word proceedings in its caption. And when I reviewed this, I'm going to tell you, Mr. Ratliff, I was angry then, and I think I'm angrier now about what you did. However, in light of allowing you some due process, I looked through a correct way to handle this, and I considered Rule 11. I'll note you've retained an attorney, Mr. Bartlett, and I have reviewed a lengthy response brief along with declarations submitted on your behalf. And procedurally, where we are, first of all, the order to show cause for me is for you to explain, Mr. Ratliff, to personally explain to me how your pleading complies with Rule 11 of the Rules of Civil Procedure. Typically, when someone shows up with an attorney, their attorney gets to argue for them. However, under certain circumstances, I don't know that the right to counsel attaches, and in particular, under a Rule 11 request, I don't believe it does. I'll note the Rule 11 is a rule of civil procedure, which typically would not apply in a criminal filing. However, there are rules under the criminal rules that states we do follow civil rules when there's no corresponding rule. And in particular, criminal rules 47 and 49 indicate that filings of motions in criminal cases are to be filed in the same way and manner, and using the word manner, in which pleadings have to be filed in civil cases. Rule 11 governs licensed attorneys and the representations they make. There's been some indication of your counsel that perhaps Rule 11 doesn't apply. I believe Rule 11 does apply. I don't believe lawyers can file whatever they want in a criminal case without being subject to the representations under Rule 11, where they certify certain things and making those filings as officers of the court. To argue otherwise would say any lawyer could file anything they want in a criminal case and not be subject to any kind of sanction under Rule 11. And I believe Rule 11 permits exactly that, for me to consider it. Rule 11 under Part C3 allows the court to conduct an inquiry on its own initiative, and the court has done this, not at the request of the parties, but at my own request, because I do have questions for Mr. Ratliff. And I'll note procedurally, while I appreciate the time and research Mr. Bartlett has put into the case, we don't have a party in this case appearing before me. Mr. Ratliff, you are not the defendant. You are not the state. You are not a prosecutor. You are not the defense attorney. You are an attorney with a license that filed something asking me to stop this trial when I don't think you had any legal standing to do that. And I'm going to give you personally an opportunity to make any explanation you want as to some of my questions. I am not going to turn this into an adjunct litigation under the auspices of this capital murder case, because quite frankly, you don't represent the defendant here. You don't represent the state. You're not a party. And I'm not going to let this devolve into a whole separate procedural mess in this case and create a record of some side issue that has nothing to do with the charges the state is currently putting evidence on for. So now that I've had my say about how we got here and why we are here, Mr. Ratliff, I have questions for you under Rule 11. And if you'd like to answer those questions personally, I will ask you some questions. If you don't want to answer those questions under the advice of counsel, I'll understand that as well. And I don't know that I even need any input from the parties. So, Mr. Ratliff, are you going to answer the court's questions as it relates to Rule 11? Okay.
Otherwise, I think really it's in the process. I think the process will be valid. So the rules regarding contempt.
I'm not in contempt. I'm not in contempt, Mr. Bartlett. Well,
It didn't what the basis was, what he had shown. Was he showing cause that he ought to be allowed to do? Was he showing cause whether or not he complied with Rule 11? Was he showing cause? We didn't know. We only learned 2 evenings ago, late on the 16th, that I was told that it was about Rule 11.
oh, was that inconvenient for you? Was that, I'm asking you a direct question. Was that inconvenient for you?
Your Honor, it was only that I didn't have the amount of notes necessary. It's not that. I'm very sorry.
Mr. Bartlett, hold on. I indicated I wasn't going to have you argue this motion. I allowed you to start making it, and you are doing precisely that. I've thought this through. I'm in Rule 11 here. I'm in a rule that governs lawyers and their pleadings. When lawyers sign off on pleadings, lawyers are responsible for their pleadings. Lawyers, unless they're facing a sanction of jail under contempt, do not necessarily have the opportunity to have counsel represent them on a Rule 11. If you file a frivolous civil complaint and a judge says, I'm going to award fees because it was frivolous, you don't get to have another lawyer from another firm jump in between you and the judge and the complaint you filed, because you have the responsibility as a licensed attorney to put your name on pleadings and stand behind your signature under those rules, under Rule 11 and what you certify, and you answer those. In my opinion, and I'm the judge here, this is how you address Rule 11. So with all due respect, Mr. Ratliff, I appreciate you attempting to and wanting to represent your client. Again, you can do that. You've talked to him before. You can talk to him after. But the questions I have on Rule 11 relate directly to a pleading that Mr. Ratliff filed as licensed attorney in this case. And I have a right to ask him about his pleading that he filed. And so if you want to take a moment to consult with him, you can do that, but I'm not going to have you argue the merits of this. That will be up to you or Mr. Ratliff.
Ask that I have an opportunity to speak with him. So thank you so much for that.
Okay, I'll take the time you need. I don't want to spend much more time this afternoon. We're in the middle of this trial. We've had evidence today. We're going to have evidence tomorrow. Make it quick and then let me know what your client wants to do.
Yes, Your Honor.
Hold on.